Tonight, we are live in Lower Manhattan awaiting a verdict in the Akai Gurley case. Officer Peter Liang charged in the killing of that unarmed man in a Brooklyn stairwell. Then, coming off his huge win in New Hampshire, Bernie Sanders now has to face Hillary Clinton on the debate stage this evening. What will her strategy be to get her mojo back? Also, top investigative journalist Peter Bergen will join us to spell out the threat from homegrown terror. Best-selling author, he's got a new book that spells out the scary truth. Good evening, everybody, and welcome to RFL. I'm Richard French. Thank you so much for joining us. We begin tonight with a high-profile Akai Gurley case. The jury is right now deliberating the fate of Officer Liang in the death of Mr. Gurley. Now, the general facts in the case, they're not in dispute. Officer Liang, on patrol with his partner, when he fired his gun in an unlit stairwell in 2014, that shot killed Akai Gurley. With more is our own Dominic Carter, who is live in Lower Manhattan outside of the courthouse. Dominic?
Well, Richard, a scurry of activity within the last couple of minutes. We were pulled into the courtroom of Judge Chum literally just minutes ago, and there was a speculation that it might be a verdict. The court officers quickly moved us in. Officer Liang walked past us, escorted by PBA delegates, and you could see a look of nervous energy on his face. At this very minute, Richard, Judge Chum is explaining the jury has asked for a definition of the charges. As we speak, Judge Chum on the second floor of this courtroom is defining the charges. The courtroom is blocked off as about 100 journalists await this highly anticipated verdict. The defense argues it was a tragic accident, but not a crime. Prosecutors countered the actions of 28-year-old rookie police officer Peter Liang was reckless and that he did little to help the dying victim. Liang faces 5 counts in the 2014 death of Akai Gurley from the incident in the dimly lit staircase of the Pink Houses here in Brooklyn. Liang is charged with manslaughter, assault, reckless endangerment, criminally negligent homicide, and official misconduct. Jurors asked to rehear testimony from Liang and other witnesses. They also handled Liang's unloaded weapon in the courtroom, pulling the trigger to see how much pressure it takes to fire. Liang said his finger was never on the trigger, but prosecutors dispute that, saying pressure must be applied for the bullet to discharge. Yesterday, the jury also asked to hear again the 911 call, which brought some members of Gurley's family to break down in tears.
He's not breathing.
He's not breathing.
All right, his girlfriend, is she willing to do CPR?
We'll be checking back with Dominic in Lower Manhattan shortly, but I want to bring in our panel to get into this. Richard Brodsky's former Democratic New York State Assemblyman, now a senior fellow at Demos and a professor at NYU. Richard St. Paul, an attorney, Republican strategist and former vice chair for the National Black Republican Association, and Andrew Whitman, our senior political correspondent. And both you guys are attorneys. And Richard, it seemed that the definition of reasonable force was at the center of this. Listen, I think everybody would agree from a policy standpoint, 2 rookie cops shouldn't be put in the housing projects together and doing a vertical search here. Nobody thinks in retrospect that was smart. That said, police policy is you're not to unholster your weapon unless there's a threat. He apparently walked in, looked up a stairwell, saw bullet holes he believed in the top of it, and decided he was going to take out his gun. All Gurley did was, elevator's broken. He's trying to open the door to go down the stairs. He opens the door. Liang shoots. In the worst case of bad luck for all involved, ricochets and kills poor Mr. Gurley. And then after it, Liang's first call reportedly is to his union rep. Instead of to dial 911 to get the bus coming up there, and moreover, he didn't administer CPR. So, again, where does it go from being a tragic mistake to something more than that? And when is it? He couldn't have died if he never took his gun out and if he never pulled the trigger.
Right. And
Which
so-
he shouldn't have done. Nobody debates that. So when does it go from a non-intentional mistake to, again, something criminal, in this case, manslaughter?
So here's what I would say. First of all, this is a very unusual trial because the judge has allowed cameras into the courtroom. That's a very rare case, especially in the case of a police officer, that you have cameras in the courtroom. And that I have to say that I think that's a good thing because it's of public interest of what's taking place, given what's happening, especially now with police officers and unarmed folks. Secondly, the minute that he had his finger on that trigger is what the reckless behavior was. Because in order to be convicted of the criminal negligent homicide or murder in the second degree, your behavior has to be so reckless that it's indifferent to life. So the minute that he had his finger on the trigger, that was the reckless behavior. And then pulling the trigger, of course, caused the death of the individual. If he didn't have his finger on the trigger, for example, that would be fine, nobody would be dead. If, for example, he heard some noise, he thought his life was in jeopardy, and then he shot accidentally because he thought he saw a weapon or something, then that would be, and there was no weapon, then that would be an accident. But as you said before, the fact that the NYPD policy says you're not supposed to pull out your gun unless you feel like you're threatened. At the time, there was no evidence that he felt like he was threatened. He should not have had his finger on that weapon when he went in the hallway.
You know, Richard, if a person in that building, whether they had a legal permit or not, was walking up the stairs and they took a gun out because they didn't feel safe, and they shot indiscriminately when they heard a noise or something when a door opened and Mr. Gurley died at their hands, we would be treating this differently. Should we?
Well, police are brought in when there is a reason for the community to be concerned, and they walk into these difficult situations. Juries tend to give them more leeway than they give a private citizen who's an armed vigilante.
But do you think the expectation should be higher or less for a trained law enforcement officer?
Well, in some sense, higher. But you know, with all these cases, we end up sort of speculating out of our own experiences, which is fine.
That's what a jury's got to do.
Well, yeah, but notice what they're looking for. They're looking for the amount of force it took to pull the trigger, and then of all the things that he's accused of, the officer's accused of, the failing to give help is I think is probably the thing that to a juror would be the most disturbing.
But isn't that a violation of police procedure as much as, if not more than actually a reason for manslaughter? I mean,
failure to aid is a crime.
Okay.
And he's being charged with that crime. He's being charged with a range of crimes.
And they're listed right there on our screen.
Right. So to what extent, and perhaps undertrained, an inexperienced cop, unintentionally, because no one has any of this down as an intentional rogue cop kind of thing, it's going to be a very delicate question for the jury, and they're obviously taking it very seriously. You get a split verdict in this. You'll get some acquittals and some convictions. I think that's what's
Well, the other thing I would say is the jury. I have to give the jury a lot of credit. They're really taking their time. It's been 3 days of deliberation. They're really taking their time. They're asking questions about, there was apparently a phone call that was received that said there were shots fired. You know, did Officer Lachang know at that time that that call came in? Was that part of his thought process of why he had his gun out, because he heard that there were shots fired earlier? That's going to play a very key role. What he knew, when he knew it, did he know that? The other thing is, that's a Glock that they use. It's I believe it's a .40 caliber, so the safety is actually in the trigger. There's no safety otherwise, so you have to use an amount of force to pull back that trigger. It just doesn't go back softly.
It's not a hair trigger.
It's not a hair trigger.
You know, and for folks who may not remember, Rich Brodsky, one-time candidate for Attorney General, this was a case, obviously in the aftermath of what happened on Staten Island, where the Attorney General of New York could have taken the case here. We could have appointed a special prosecutor to this case. In this particular case, the DA in Brooklyn said, no, I've got this. And he vocally said, I'm going to pursue an indictment. It wasn't that I'll present it to the grand jury, we'll see where they go. He made the argument and we're looking at the DA there, that I don't need help, in effect, from Albany here. I've got this one on my own. Obviously, he got the indictment. That's where we are right now. But it's certainly reversal from certainly what we saw with Donovan in Staten Island and what we've seen in other cases. Are you comfortable for that? In a perverse way, if you were the officer, if you have already a DA who's already, intending to prove your guilt before you've even laid out the facts.
You can't judge the wisdom of the Attorney General's power to supersede based on the outcome of any particular case.
I'm not even saying the outcome, Richard. I'm saying, just as I was critical of, in St. Louis, the DA in that particular case, making it clear he was not taking a position when presenting the facts, but almost talking the grand jury out of an indictment. Conversely, could you make an argument if you were Officer Liang, hey, I got a DA who's already trying to direct somebody to
are
indict?
Supposed to make these judgments. That's why we have them. They're supposed to talk the grand jury out when it's the wrong thing to do, and they're supposed to persuade the grand jury to indict when they think it is. This is one of those cases where there are no really awful characters. Everybody, to some extent, is a victim, especially Mr. Gurley, who is dead.
No longer with us.
I mean, this is different than the Garner case. This is different than the Trayvon Martin case. This is different than the other cases where there were witnesses, there was a confrontation, there was back and forth.
There was an action and a reaction. In this particular case, all this guy did, Andrew, was open a doorway in a building that he lives in, and for that, he's no longer with us. And it's one of those where nobody thinks Officer Liang set out that day to kill somebody. But if you're the Gurley family right now, there's a little child without her father anymore. And is that just a mistake? I was talking to the attorneys yesterday, and I said, part of me says, whenever there's this civil portion of the trial, it always feels like a payoff. Whether it is or not, it's not the point. It feels like hush money so that it'll make it go away. Whether that's fair or not, that's the perception out there. And sometimes I do think it's fair, that characterization. In a perverse way, and I'm not saying it applies in this case, because I do think maybe a conviction's warranted from at least the evidence we've seen. But sometimes it feels like almost at the same setting where you go, the state says, listen, this was a tragedy that happened. We don't believe it was criminal, the actions, but nonetheless, we want to make the family whole. If you could do that in a way where it's more timely, I think there'd be a little bit more faith in the system.
What this is, if this is going to be useful, not just for the justice of a particular verdict, it will focus again on one of the underlying critiques of police now, which is that they're not trained appropriately for when to use deadly force. And in that case, you can compare this to the Martin case and the Garner case.
But I don't agree with this one, Andrew, because he was clearly, police protocol was, you don't take your gun out when you're doing a vertical search unless there's a clear and present threat. To walk in and say it's a scary building because it's not lit, I'm not saying I want to go to that projects and walk up the thing myself.
But he was also
but
responding.
You volunteered to take the gig.
He was responding to a call, and I think there was an assumption that he might have been walking into a dangerous situation. And while I don't think I suspect he probably violated some police protocols pretty obviously, I'm not sure where justice is in all this. And you were talking about Ferguson, and you were talking about the Garner case, or Baltimore, all these other cases that we've had. The case in Cleveland. The big problem in the community has been a perception that there's been no justice as a result of the outcomes of all of those cases. And my question, I want to ask everybody else, if there's a procedural conviction, action on becoming, or whatever the case might be, that's one thing. But if he's acquitted of manslaughter, will there be a sense that justice hasn't been done in the case?
It's negligent homicide. No, the prosecutors aren't even charging him with an intentional act. Well. No. With a mean, and then no one says he meant to do it.
But it's the perception in the community based on the result. And will there be a sense that, and he is charged with manslaughter.
This is very similar to getting in your car, drunk, driving down the street and killing somebody because you're drunk. Now, you didn't mean to kill that person. It was an accident, but your reckless behavior caused the death. His reckless behavior, hand on the trigger, caused somebody's death. That's the equivalency. That's what we're talking about.
And that sounds like reckless intent. I'm just wondering what the threshold for which the community will feel like justice has been
force.
done.
Two people can look at the same situation and come to two different conclusions when it is reasonable to know or not.
You don't get a conviction when two people can disagree. There's got to be a consensus that it wasn't.
Okay, as you said, Dominic's down there live. Any updates in the case, we'll take you back down to Brooklyn to get the very latest. Coming up next, though, we will pivot to politics and the race to the White House. Now, the question is tonight, with the next debate on tap, will Hillary Clinton go after Bernie Sanders in the debate this evening? We'll talk about how much Hillary can get some momentum after a big loss in New Hampshire and just how much trouble her campaign may really be in.